Well, for a holistic review of the Presidential Election Petition Tribunal ruling, I'm delighted to have now been joined in the studios by the erudite, and some will call him sagacious, senior advocate of Nigeria, Femi Falana. Very warm welcome.
Thank you very much.
Yeah, I mean, the PEPT, as we now call it now, the acronym for the Presidential Election Petition Tribunal, you know, the verdict is drawn a lot of flags, you know, good and bad and the rest. How would you want to, you know, just look at the corpus of that judgment that lasted for 9 hours before we come to specifics?
Well, for me as a Nigerian, I am disturbed that we continue to drag the judiciary into the determination of winners of election. Judges are not suited to determine the winners of election. That is the exclusive preserve of the electorate. And so, for me, cases like this throw up a challenge that we need to go back to the drawing table and reorganize our electoral system in a way that we can conduct credible elections, elections whose results will be determined by the electorate and not by the courts.
Absolutely. That is what Professor Mohammed Taufik Ladan is saying in one of his articles. Yeah. He said the provisions of INEC guidelines, regulations, and manuals should be made available to the judiciary ahead of elections with a view to ensuring that courts are up to date on the legal framework for the conduct of elections in Nigeria. You think that the court, the judiciary, is, you know, not adequately, you know, to envision some of these provisions?
No, with profound respect to Professor Ladan, the point I'm making is that we must try as much as possible to keep judges out of our electoral system. There's no place for judges in determining who wins an election.
But once there's a dispute,
you know what? Once there is now a dispute, we now take the elections to the courtroom, and there are no provisions in the courtroom to determine the winners of election. What judges are then compelled to do is to apply our very reactionary electoral jurisprudence to the facts presented by the petitioners. And at the end of the day, our judicial system is anchored essentially on technicalities.
I was going to come to that.
And therefore,
yeah,
people, when you drag the judiciary into the electoral system, you expose the judiciary to a lot of embarrassment, and it's not good for any country.
With the present situation right now, it looks from what your submission, it's like the integrity of the judiciary is in question.
No,
particularly,
it's at stake.
Is at stake, is in question, a matter of semantics here. What is the essence of justice then when the judiciary will base judgment on technicalities? I have two cases at hand. First is, I ask, for example, why are the courts always quick to dismiss cases on technical grounds and leaving undecided the substance of a matter? For example, Oni versus Fawemi, that went as far as the Supreme Court, where Oni was challenging Fawemi, you understand, that he ought to have resigned before contesting a political position. And the court ruled that because it was statute bar, the subject of the matter, they never give us an insight into what the law should really be. Does that improve our jurisprudence?
No, you see, again, you must appreciate that we have come a long way with respect to our electoral jurisprudence. In this country, particularly in the case of Ngige and Obi, which lasted for about 3 years out of a 4-year tenure of the governor. That case forced a review of the system.
Of the Electoral Act.
Yeah.
Too. Yeah.
Whereby Section 285 of the Constitution was amended to limit the time for
adjudication.
adjudicating on electoral petitions to 180 days. Now, once the Constitution has imposed a time limit, the courts cannot dance around it. So that is the problem with respect to pre-election matters. The law says you must file the petition or your complaint within 14 days after the conduct of primaries of the parties. If you don't do so within 14 days, there's no magic that can make the court to say, oh, whereas you didn't file it within 14 days, you file it on the 15th or 16th day or the 20th day. The Supreme Court or any of our court has no jurisdiction.
But Femi, sometimes, I mean, the laws are made for man, you know, not man for the laws.
Yeah.
Where does discretion come into the discretion into legal issues now?
Judicial discretion comes in when a court has the jurisdictional competence to decide a matter. And you then look at the justice of it. And what our courts try to do now is to ensure that substantial justice takes precedence over technical justice. Unfortunately, in the case of election petitions,
the reverse is the case.
No, you see,
it
is the nature of our electoral system.
Yes, but the reverse is the case, and it is really making the people awry because they don't seem to get justice. Technicalities. Why? No. Why is it? I mean, generally we operate the common law. I don't think that obtains in the UK too, or in India.
No,
I mean, in Commonwealth countries.
It does.
You know,
it does.
To say you file the matter out of time.
That is why we say election petitions are sui generis. They are a special type of cases. They are on their own. Because you can't keep an election petition in court for 4 years. Because that is the normal term of office of a winner of an election. So if you say, oh, you go back to court and start again, like a regular case, you defeat the cause of justice. And you also mess up the electorate that believes, oh, the term of office of the winner of an election is 4 years. Now, you've been in the Supreme Court from the Election Petition Tribunal to the Supreme Court. You want to spend 3 years, you then say go back. And then the entire time is wasted on pursuing an election petition. But if it were a regular case, the court may feel, oh, justice has not been done in this case. You go back and start all over. But with respect to election petition, the judges are timed. And so you can't go outside the time provided by the Constitution. That's the problem with election petitions. Okay,
we're going to examine more of these and see how really the nation's jurisprudence can be improved, particularly with the fallout of the Presidential Election Petition Tribunal's judgment and the rest. You're still watching the Arise interview. We've got more to come, including we'll continue the chats, like we said, with the erudite Femi Falana as he reviews the outcome of the Presidential Election Petition Tribunal. Stay with us. You're welcome back to the Arise interview, where we speak to the newsmakers as well as ordinary people doing extraordinary things around the world and featuring the voices at the heart of the stories. I am Christian Ogodo. Thanks for staying with us. The ruling All Progressives Congress have boasted that they are confident that if it is within the Nigerian law for the PDP to go even to the World Court, they will meet them there. Although President Muhammadu Buhari has exhibited the attributes of a statesman by extending a hand of fellowship to the opposition PDP moments after the Presidential Election Petition Tribunal dismissed in its entirety the petition filed by Atiku Abubakar. The five-man tribunal, chaired by Justice Mohammed Garba in a unanimous judgment, upheld the victory of President Muhammadu Buhari in the 23rd February election. In a moment, we'll continue our chat with Femi Falana, senior advocate of Nigeria and rights activist. First, here is another reaction to the outcome of the Presidential Election Petition Tribunal.
At the Election Petition Tribunal, Nigeria will hail thee. Hey, now wow. Well, we said it, and we are not surprised in any way, the technicalities and all what have you. We are not surprised in any way. Now, what is even more strange was the manner in which the judges of the Court of Appeal descended so low into the arena. It is very, very unfortunate. It's really where the Court of Appeal was not defending the president, was not telling us about the CV of the president. A president that does not have certificates, a president that did not submit any CV to INEC, the president submitted only a court affidavit to INEC. So where did the judges get the CV of the president from? You know that? They want to make Nigeria a laughingstock to the entire world. It is very sad. Young lawyers are watching. Law students are watching. People who have not even gone to law school are watching. What kind of a country are we building? A country where we say that educational qualification does not matter, anyone can become president? A country where we say that our constitution that was written does not matter? Because even if they say that the WAEC is not needed, where is the equivalent? The president did not submit the equivalent. The issues before the court are very simple.
Well, we'll continue with the interview with the senior advocate of Nigeria, Mr. Femi Falana. Femi, let me take your mind again back to the Osun Governorship Election Tribunal, the decision of the appellate court, that is the appeal and the Supreme Court on that matter, was hinged on technicality, not on the subject matter of the petition. Ditto, the judgment was that Justice Obiora, one of the three judges on that panel, did not just one day signed the register. And because of that, he was not competent to have given an opinion or delivered the judgment of that tribunal. Is that justiciable?
Now, within the ambit of our law, and having regards to many decisions of our courts, it is difficult to fault the judgment on that score. And the Supreme Court made the point that in ordinary cases, in regular cases, that matter will have been sent back to the lower court for another panel to look at it. Unfortunately, again, there is a time limit. We're once in the Supreme Court for an election petition. The court has us go back and have the substantive matter tried because our opponents had fought the matter on technicality from the tribunal to the Supreme Court. Of course, we went back. When we got back, our colleagues, after about a month, challenged the competence of the proceedings on the ground that time had passed. Again, we were confident, it was the Supreme Court that asked us to come back. By the time we got back to the Supreme Court, the court said, too bad. Your time is up. We cannot amend the Constitution. You have 180 days, and 180 days are over. In this case, in the case of Osun State, whereas 3 judges are required to hear and determine the petition, if for any reason, one, for reasons best known to him, did not attend the proceedings, he cannot sign the judgment. If he does sign the judgment, that will vitiate the entire judgment. Because if you did not listen to the evidence, if you did not hear the witnesses, how did you arrive at your decision? And that was the point the court was making. And there are many decisions of our court. I mean, I just got 4 out of the 70 soldiers that were sentenced to death, in 2014, released by the Court of Appeal on the ground that the judgment was delivered by the court martial, but it was never signed until I think about 2 or 3 months later. And the court said, no. You ought to have signed the judgment. When you wrote it, how are we sure that it wasn't a different judgment that you were signing? My clients have been sentenced to death. So we're talking of their right to life. And the trial has to be transparently conducted. In this case, of course, the court cannot look at the substantive matter if the panel is not properly constituted. So we're talking of the form and the content of a judgment. If a court is not properly constituted, that is the end of the decision, however well conducted. And that was what happened in the case of Osun. For me, these are lessons for us if we have to go back and reform our electoral process. And I think that would be the beauty of the appeal that is being pursued by Alhaji Atiku Abubakar.
Okay, let's look at the issue of electoral justice and integrity of the judicial process in election cases. Take, for example, judgments, the conflicting judgments in the validity of cases where the smart card reader is brought before the court. You have 7 decisions saying it was appropriate to use smart card readers. And the same judicial system again, or the same judiciary again, in another 18 is saying, no, you cannot use the smart card readers. Up to the Supreme Court. Why the conflict of, judgments here on one issue?
Okay. If I can explain this, because I've had cause to intervene.
Okay.
When the Supreme Court gave its judgment, and once on any matter, the judgment of the Supreme Court is final. And like Justice Jackson of the United States of America said, when you are talking of this judgment of the Supreme Court, it is often said that it is final, not because the judges are infallible, right? But they are infallible because their judgment is final. If you lose in the Supreme Court, so be it. Unless the law is amended, there's nothing you can do. In fact, we often tell our clients, when after losing a case in the Supreme Court, and your client asks you, what do we do now? Appeal lies with the Almighty God. Now, with respect to the use of queried, unfortunately, when the Supreme Court gave its judgment in 2015, neither the court nor the counsel on both sides, or on all the sides, alluded to the amendment carried out by the National Assembly on the 27th of March 2015. It was in the course of reviewing the judgment that I pointed out that by virtue of Section 52 of the Electoral Act as amended, INEC has been empowered to use any procedure deemed fit in the conduct of elections, and therefore, queried was allowed by law. And since then, we've been using the queried readers. But before then, there was no certainty in the law. And the minds of our judges and lawyers were not adverted to,
that section.
To that section of the law. And that was what caused the confusion. But now the law is very clear.
Okay, well, we have just very few minutes before we go on break, Femi. I want to take you straight into the judgment of the PEPT, that's the latest acronym now.
Yeah.
And the chairman of the tribunal, Justice Muhammad Garba, had said that Mr. President is not only eminently qualified to run for that position as against the petition by the petitioners, that he swore to an affidavit and not the presentation of a certificate. Which comes first, still on the integrity and is the technicality of our laws? Affidavit or the certificate?
Now, it depends on the way you look at it.
No, remember the military board is supposed to have the president's certificate.
Now, I think the argument here is that the president perjured when he swore to an affidavit.
There is a perjury there.
To the effect, no, that's the allegation.
Yeah.
To the effect that he had submitted his certificate, his school certificate, to the military. And the military said, no, we don't have it. Now, there is a problem there. I disagree with the conclusion of the court. Because the court cannot choose and pick which version was correct. But there is a Supreme Court judgment to the effect that Section 34 of the Electoral Act that requires anybody to lodge a complaint if you are sure that somebody has made a false deposition. The Supreme Court is saying, sorry, that condition in the Electoral Act cannot take precedence over the constitutional provision that once you meet the conditions set out by the Constitution, no other condition can be imposed.
Can override that.
Yes. And that therefore,
okay, sorry. I'm so sorry to.
That's the law.
I'm so sorry to put you on pause.
That's why I'm saying that I disagree with the court. That is the applicable law.
Okay. We'll come back and you expatiate further on that. You're still watching the Rise interview. We'll still go plenty more ahead. And, of course, the erudite Femi Falana is still with us. Stay with us. You're welcome back to the Arise interview, and I still have Femi Falana, SAN. I want you to expatiate, further about the submission you were making about this certificate affidavit, whether the president perjured or alleged to have perjured.
You see?
Yeah.
Again, there are decisions of our court to the effect that before you can accuse somebody of perjury, you must have taken him to court and have him prosecuted. The Election Petition Tribunal is not the forum for that. That's number one. Number two, the Supreme Court is saying in Ikweazu and PDP that once you meet the conditions set out in the Constitution, you cannot import any other one, including Section 34 that everybody is talking about. Where are we then?
Are we being sentimental?
Section 318 of the Constitution provides. It does not say you must have a school certificate. It says you must be educated up to school certificate level. In Adeleke's case in Osun, that came up. Some of his party people sued him. That you hire people to write school cert for you, therefore you didn't have a school certificate. The Supreme Court said,
it's not the business.
That's not the business.
Yeah.
Was he educated up to secondary school level before he could be hiring people to write his exam?
That's a different matter entirely.
Now, we didn't look at the implication there. Now, if that case is now cited, the Court of Appeal is bound by it, by the decision of the Supreme Court. The point I'm making, therefore, is that by virtue of Section 318, education up to school cert level, possession of primary school certificate, and work experience for 10 years, either in the private or public sector,
will qualify.
Will qualify. Or, if INEC in his wisdom feels that you are qualified, it's in that Constitution. You are so qualified. Cases like this should drive us back to the drawing table
of the Electoral Act.
Of course.
The entire electoral, electoral
Can we
process.
go on like this?
Yeah.
Have we not been exposed to ridicule? If we have to contest whether our president is qualified to run, to contest the election. As a matter of fact, again, there are decisions of our court to defer that such matters regarding qualification are pre-election
Election
matter.
matters.
They should have been raised before the election. So in other words, before the man goes for the election, you should have raised them. So the court was being general by saying, okay, we entertain it, even though the conclusion may be wrong. But again, there are decisions of our courts. My own worry in all this is that we are going through
A vicious
a
circle.
vicious circle of irrelevance.
A vicious circle that probably would have been corrected more than 20 years ago.
Yes, for 16 years, we pleaded with the PDP when it was in power. Let us reform this
Process.
dangerous electoral system. But we're told then that the PDP will be in power for 60 years. And therefore, we didn't need to amend anything. So the PDP enjoyed
The benefits of the windfall
benefit
then.
of, windfall of this very dangerous electoral system. The late President Muhammadu was very honest when he came out publicly to say,
The 2011 election
no,
was...
2007, that
Yeah,
produced me
2007, sorry, yeah.
was highly flawed.
Yeah.
Therefore, let us look at it. So a panel was set up, headed by
Justice
the Honorable Justice
Uwais.
Muhammad Buhari, a former Chief Justice of Nigeria. They came out with very profound recommendations. They were ignored by the government. Following the crisis in 2011, President Jonathan set up the Amen Lemu Committee. That panel updated
The Uwais
report
report.
as it were. Again, the recommendations were ignored, including the fact that we have to set up an electoral offenses tribunal to deal with those who manipulate election results in Nigeria, to deal with all manners of electoral offenders. Up to now, that has not been set up. With respect to the current administration, President Buhari set up the Ken Namani panel, again to look at our electoral system. That panel also examined the reports of the previous panel, including the recommendations of the 2014 National Conference, and came up with recommendations that could improve the electoral system. Again, the current regime has treated the report with disdain.
Political,
And of course,
political selfishness?
we have been told now by the APC that it's going to win the 2023 election, and perhaps beyond that.
And rule for 60 years that the PDP
Of course,
couldn't.
under the current electoral system. But if the APC is defeated tomorrow, or in 2023 or thereafter, it will have itself to blame if it does not reform the electoral system now. Last year, President Buhari said, sorry, the amendment of the Electoral Act, the Electoral Amendment Bill passed by the National Assembly could not be assented to by him because it came rather too close to the election. Now the elections are over. Where do we stand? The elections are over. You would therefore have expected the government to ask the National Assembly, controlled by the ruling party, can we update the bill based on our experience in the 2019 election so that in 2023 we can have credible elections conducted in this country? That has not happened.
Nobody seems to be interested in elections being credible, but they want the judiciary to adjudicate, beyond,
and give judgment beyond the law.
provisions of the law.
It's difficult. Again, like I said, the judiciary is hamstrung. You are limited to interpret the law, and particularly for tribunals, Election Petition Tribunal, and the Court of Appeal. You are bound by the decisions of the Supreme Court. In Buhari and Obasanjo in 2005, the late Honorable Justice Pat Ashelonu warned all of us. In fact, he referred to it as legal impossibility of proving election petitions in a presidential or governorship election, according to his lordship, you will need 250,000 to 300,000 witnesses to prove the validity of an or invalidity of an election petition.
Within 14 days.
No, at that time,
it was open-ended.
It was open-ended. But it's worse now, because you must do so within 180 days. In the case of Atiku and INEC, Atiku Abubakar and INEC, the petitioner was given only 10 days. How many witnesses are you going to call in 10 days who are going to be cross-examined by the counsel to the respondents? So this is the legal dilemma we are in. His Lordship, the Honorable Justice Pat Asholonu, described the 2003 general election, the do or die election, as blood curdling, in the words of Shakespeare, in Macbeth. That was the way His Lordship put it. And that we must henceforth educate our people to appreciate the need to vote for credible people. We must educate the security officers, security personnel, to appreciate that they must be neutral in the management of elections, and so on and so forth. All those recommendations by His Lordship have been ignored by the ruling class. And so, that is why we're in this dilemma. To make it worse, you are not going to have credible elections if election riggers and manipulators are given immunity. In some countries, once an election is concluded, all those who perpetrated electoral malfeasance are taken to court the following day or thereabout. Here, INEC is asked to prosecute. INEC is overburdened with conducting elections. INEC is asked to register political parties. And we have recommended over the time, unbundle INEC so that it can be, INEC can.
In what kind of compartmentalization are you talking of now?
No, you must have another body that will, an electoral offences commission and tribunal that will collaborate with the police to deal with those who have committed electoral offences. During the last election, the 2019 election, more than 2,000 people were arrested before the election and during the election. Up to now,
none has been
charged for any offense in any court. So what you are simply telling them is, you go back home and prepare for the next election and disrupt the next election. You even have a situation where armed robbery suspect in one of the states in the North Central came out to say, sorry, we are not armed robbers, we are political thugs. In Taraba, an alleged notorious kidnapper was recently arrested. He said, no, I'm not a kidnapper, I am a political thug. And in fact, he gave details of a party that gave him 13 million naira, another gave 6 million naira. Nobody has really challenged his claim. So once you have a country where there is no sanction for impunity, you cannot get it the rule of law or law and order right. And that is the dilemma.
So it's not just an individual matter. Even the political parties are lengthy beneath. The institutions.
It's the institutions. We must put in place a mechanism for dealing with criminal suspects. And it's not just about election. The members of our ruling class go abroad to UAE, to London, even to Ghana, Accra. Once they land in those cities, everybody adjusts himself. But here, you're a big woman or a big man. So you don't obey the law here. Where?
Okay, let me put you on another pause because we want to take another break and some commercial messages. You're watching the Arise interview. Stay with us. We've got more to come. You're welcome back to the Arise interview. I still have the senior advocate, Femi Falana, here. Femi, let's look. You've raised a lot of hair-raising issues here about the judiciary not being helpless, but it's like their hands are tied in some cases within the constitutionality of matters brought before it. I want us to look again at the issue of the server pleaded by the PDP and Atiku, its presidential candidate, that there exists or existed a server in INEC and the rest. But the court simply said it was based on hearsay. There wasn't any evidence to prove that.
Excuse me. Under our law, it is strikes that he who asserts must prove.
Yeah.
If you say there is a server or server was used by INEC, the onus is on you to prove that INEC used server. When the star witness gave evidence, he was asked, a former minister, how did you arrive at the conclusion that server was used? So they got the information from a whistleblower.
Yes. The courts don't listen to hearsay.
Of course. So you cannot expect the court to manufacture evidence of the server.
Yeah, but why did the court again denied the appellant the right to go and inspect electoral materials and even the server? Why would the court take such a decision?
For me, the court has a duty to assist the parties if they make an application to inspect materials. I will not support.
And why was INEC insistent that no, they were not going to bring their
materials? You see, let me tell you. Again, I do hope that my advice will be taken seriously one day. My position is that, and there are a couple of cases that support this. Whereas INEC says it has conducted credible elections. If there is a serious challenge, for me, INEC should be the one, the owner should be on INEC to go to court and prove how it has conducted good elections. But the reverse is the case. The petitioner is asked to prove that INEC did not conduct credible elections.
And yet INEC is not ready to release documents appropriate.
No, INEC will ask you, you go and get an order. And the matter is argued, one way or the other, the court may say no, let's move on, there's no time.
Why would the court say no to important evidential piece that an appellant needs in an electoral matter?
Now, as far as the law is concerned now, it's almost automatic that you have to be given the order to inspect all material. As a matter of fact.
But we didn't say that.
No, you see.
You don't ask, I mean, the court is not a Father Christmas.
We have to move. All right. In fact, under the Freedom of Information Act, Section 1 of that law says, all documents in the custody of the government shall be made available to anybody who requests within 7 days. Yeah. So we have to look at the totality of our law and invoke the provisions when we are confronted with problems like this. But again, as I said, for me, I hope we amend our law to impose, to shift the onus of proof on INEC to prove that it has conducted good election. Because the petitioner is at a disadvantage. In fact, I know very senior lawyers who do not handle cases for petitioners because of the difficulty.
Electoral petitions.
Oh, yeah.
You are one of them now.
Handle petitions for the respondents because it's easier. to go to court and raise objections.
You don't even handle political
No,
matters.
not now. No, I don't
Yeah, I
handle
mean now,
election
yeah.
petition matters now.
Yeah, why?
I'm otherwise committed. I'm otherwise committed.
We
I'm
know-
otherwise
we know-
committed.
We know you're committed.
I'm otherwise committed.
But why? I mean, with all the, erudition that you've postulated here, submitted here, one would say, okay, Falana is going to make a good loyalty petition.
I thank you for the compliment, but I'm saying that we are also trying as much as possible to specialize. In legal practice in Nigeria, lawyers are now trying to specialize. And I have moved away from that
Electoral
area
matters.
of the law. I'm with my age now, and I'm no longer getting younger. I'm almost restricting myself to constitutional law, human rights, and related matters. But I still,
Consult
engage.
for-
Yeah, I engage in campaign for credible elections, and I can also tell you, I'm working with. I'm trying to collaborate with INEC to ensure that all those who were arrested during the last election for violating the Electoral Act are prosecuted. And the last time I asked the INEC chairman, Professor Mahmoud, he did inform me that they are waiting, that INEC is waiting for police report in respect of those, cases of electoral. Well, in 2011, we're able to get lawyers, we're able to get the NBA and the INEC to work together to prosecute electoral offenders. And I think that is possible this time around.
Okay, Femi, we don't have so much time left, but let's quickly look at your client, Sowore. What's happening to him right now? Are you in contact with Sowore?
Yes, I'm in contact with him. His spirits are high, very, very high. He appreciates, what he's going through. And if you recall that he was a president of the University of Lagos student, at the time, I think in the 90s. And he went through a lot of, crisis within this, vis-a-vis the state, this neo-colonial state. And so it's not in any way perturbed by his experience.
So he's in good spirits, good
in
health?
Spirit, he's in good spirit and asks us to, continue
The legal
battle
yeah.
for his release. Unfortunately, we haven't gotten a hearing of his application, whereas the order for his detention was
expeditiously
was within 48 hours, and within 24 hours thereafter, we file our motion. Now it's almost a month. We haven't got a hearing date, and just a couple of days ago, we've approached the court for bail for him because we suspect that, in case the order is renewed, we want to move an application for bail. So it's okay. It's okay.
Okay, that's fine. And your other client in Kaduna, Elzakzaky, what's the state now? Is the state reworking his, medical trip again abroad after the botched one in India?
I will not say for now, because I think there are moves to review,
His
the
detention, the whole case.
And, have their health attended to. And I'm talking of Elzakzaky and his wife, who have been confirmed by local and foreign doctors to be in a very bad shape, health-wise. So I do hope that the government will, speedily resolve the matter. The Indian experience was very terrible, and I think the government will have to, review the entire, health challenge and ensure that they remain alive to be able to stand trial.
You didn't go for that trip, neither did his personal physician.
No, the personal physician went with them, but was not allowed to be part of, the medical examination. So and I think that was part of the problem.
So he was practically still in custody over there?
Oh, yeah, in Kaduna, yeah, he's still in custody, and his wife.
And you're reaching, what are you saying to the IMN people? Very briefly, the movement and the rest, they still defy, police orders and the court order that declared them a terrorist organization, even though I know that this thing is being challenged in court.
The court has secretly pronounced the organization dead through an ex parte application. But the court has never authorized the police to prevent the Shiites from worshiping their God.
Thank you very much. Senior Advocate of Nigeria, erudite lawyer, human rights lawyer, Femi Falana, for throwing more light on all corpus of the Nigerian judiciary and the electoral process. So wonderful to have you.
Thank you very much. My pleasure.
Thank you. Well, that's it for this edition of the Arise interview. Remember to join us again for a fresh edition tomorrow. From me and the entire team here in Abuja, goodbye and thanks for watching.